Ladies and gentlemen, welcome. This is William Keat of lawandalchemy.org and commonlawconstitution.org. Welcome. This is going to be an important video commenting on some interesting things that have been happening over the last 5 or 6 days, which I'm sure you've noticed, um, which all kicked off a sort of a furore over the issue of trial by jury. And obviously, I haven't spoken about this yet. I wanted to watch what was going on a bit before making a comment. Well, it's been interesting, and it was all kicked off, of course, a few days ago by a leaked memo from David Lammy's office, followed eventually, of course, by his actual statement of his intention. Now, what I should probably do is just very briefly, in about 1 minute, just talk a little bit about the backstory, which is, of course, the Leveson review, which has now been completed. Happened came to fruition in July. That's when Sir Brian released his proposals, his recommendations, and in those recommendations, they include, of course, a significant reduction in trial by jury with the introduction of an intermediate court. Now, this has been going on for a year. It was about a year ago, just under, that I kicked off the information about this and sort of brought it, maybe I hope, to the attention of people. So that process was sort of started then. And we've had, as I say, nearly a year, and mostly it's been pretty silent. Not a lot of people have talked about it, and a few have mentioned it when pushed a little bit. But there's been precious little, at least in the freedom movement. Now, this is quite serious, as people know. This affects a defendant's right to be tried by a jury in the Crown Court. And if you want to get up to speed on this, I produced, soon after the proposals were released, I produced a video called Leveson at a Glance. And in that, I produced a video. One of my contributors contributed a written piece of information, and we broke down what the implications are for that for a defendant in this new situation, and it's pretty significant. Now, going back to the leak at the time, what that did is it revealed Lammy's own proposals, which were going to go further even than Sir Brian Leveson in his review, in which Lammy was suggesting that jury trials would potentially be scrapped for all but the most serious offences. And so that would be murder, rape, and manslaughter. Now, that would have been considerably further than Sir Brian Leveson's proposals. So what this did is it caused an absolute uproar, a kind of firestorm, which is good. But what was interesting is, why did that happen? What's the analysis of this? Well, it could be that sneakily David Lammy was, kind of trying to cast himself perhaps as a kind of good cop in a kind of good cop, bad cop scenario, in which he was kind of casting himself as the bad cop, so that, then when he later released his statement of what he actually intended to do, which perhaps was much more closely back to the Leveson proposals, it might appear a bit more acceptable. Make it look worse so that his climb down or return is then sort of appreciated, right? So was all that deliberate, right? Who knows? Now, the alternative is that at least has crossed my mind, perhaps. Was David Lammy alternatively playing a white hat in this? Maybe he would never have got the attention to this situation and the attention and upset over this if he hadn't released this leak, in order to bring our attention to an issue that is absolutely vital, that we'd largely been ignoring for a year. Now, the legal profession hadn't actually been ignoring it. They'd actually paid a bit more attention to it. But, the broad mass of the population, absolute silence, and the freedom movement also didn't really pay it that much attention either, I'm sorry to say. But the firestorm of disapproval has been interesting, because it's not let up, and that's good. That's positive. The disapproval seems to be no less for the more reasonable Leveson position than it would have been for a more extreme cutback of juries to almost nothing. So it hasn't been, the disapproval and the pushback is still there, even though he's pulled back to a more reasonable position. It's not really reasonable. It's also unacceptable as well. So what has been happening? The storm of protest has been encouraging, absolutely. But here come Will's caveats. So it's interesting that most of the protest, I would say, is coming, as I've already said, from the legal profession. And lawyers are making some really good points and arguments in defense of trial by jury. And also, importantly, in the fact that the court backlogs, which is what all of this is about, isn't it, with the review, would not be fixed by a further restriction on jury trial. Wouldn't have any difference, wouldn't make any difference on that. And they're making that point. You also see some real passion here too. Many of them, you can tell, are very angry and feel quite upset by this threat, which is interesting, isn't it? So why now suddenly? What's going on? Well, it may be that the legal profession never quite believed that this threat would be carried through. Yeah, why is that? Because they've seen it before many times. Yeah, so if you have seen any in action from them, that probably would be the reason why. But they do like trial by jury, and I've said this many times to people in the freedom movement. Now, interestingly, there is very little noise and commentary from the freedom movement, the movement that we would think is more, concerned about liberties and the more dissident communities, if you like. Almost nothing. Crickets, I would say, especially from the bigger platforms. It's not nothing, but it's small. Yeah, and I would say that the passion is not there, and we're not seeing repeated discussion and concerns. So it's the legal profession, ladies and gentlemen, that are actually getting stuck in on defending your most powerful mechanism of justice. Yeah, it's them, actually. Yeah, whilst the freedom movement actually is providing very little commentary or pushback. And it's usually the freedom movement that likes to hurl abuse at the legal profession. I think that's interesting, and I've said that before. Yeah. Now, what are the reasons do we think for the freedom movement's largely position of silence on this? Well, it's partly confidence and not talking about this regularly enough, because that leads you to a position of having done insufficient reading and preparation for being able to talk about it, which is precisely why, when we knew that this moment was going to come at some point, there would be some more energy. You're going to need to be ready for it and prepared. That means you need to do the reading, and we're not there. And that's why people, I would say, who are concerned about their liberties are not really speaking about these subjects because they feel unable to do so. Well, I think it's partly that. I think it's part. Just sort out the sun there. I think it's partly that. I also think, and I've said this before recently, that I think the movement is heavily infiltrated, and I think that there are deceptive games being played as well. I'm just being honest. Sorry. So, what are the arguments that we are hearing, and where are we hearing them? Well, most of the action has been taking place, I would say, on Twitter, X. I think there's a smaller amount happening on Substack, quite a bit less actually on that platform, but I'm not really on other things, so I don't really know, but certainly I've seen a heck of a lot of activity on X. So what are we seeing? Well, we're seeing some really good practical arguments being made by lawyers that are setting out clearly the real reasons for this crisis, this backlog. Sorry, I'm just still having issues with this sun. But I need to get myself into a better place, don't I, with backdrops and things like that. Apologies. So, what are these arguments that that lawyers are making? Well, firstly, that there aren't enough lawyers, and this is absolutely true. Frontline legal aid advocacy, solicitor numbers have dropped considerably. And why is that? Well, that happened due to sort of policies back in, I think it was around 2015, 16. And we saw a huge drop in numbers. They got out and they became demoralized as well for all kinds of reasons, which I won't go into now, but I have been into it before. We've got problems with the physical court infrastructure, and they're making this point well. That's, that's kind of breaking down. Heating systems, leaks in the roof. I've talked about this before. Legal professionals know this only too well. Jurors sitting in hats and scarves in the winter because the heating system's broken down. I've sort of said that. Prisoner cells, too hot in hot weather. No air conditioning, and they can't keep prisoners in the cells. That's a problem. I saw one example of a lawyer posting a tweet, very amusing picture of a gent's urinals where all three were taped up, saying out of order, which, apparently had been like that for months. Yeah, this is the kind of thing that's going on. We had lawyers giving examples of delays, cancellations of hearings due to defendants not being brought to court by the prisoner escort system. Chaos. Yeah, this is the kind of thing that's going on. I've mentioned that before. Interpreters not getting booked in. That was a problem. There was one example, I think it might have been the secret barrister tweeting about this, that there was an example of a complainant who had not been told by the witness service or the CPS of the date of a hearing or a trial until only a few days before. Yeah, so this particular individual wasn't available, and then the date of the hearing was put back to 2027. Right, good example. This is the kind of thing that's going on. Right, so we've got hours and hours being wasted through inefficiency. Sitting days are being restricted by government because of funding. Right, there are empty courts at times. These are the real reasons why we have a backlog in the justice system. And the lawyers are making this absolutely clear and have been over the last 4 or 5 days. Brilliant. So we need to think about this. It's interesting because, the government knew about this. I've known about this all the time for years, actually, if we're being honest. And Sir Brian was doing this review in the last year, and they've known about it then because it was coming out. And they've also known at least since his report back in the summer, in July. Yeah, but nothing has been done to sort these more practical issues out, despite knowing about them. Yeah, they would rather destroy your constitutional principle of trial by jury instead. I mean, it's just, it's breathtaking, frankly. So the lack of strength of commentary has been interesting, right? In the freedom movement I've talked about, if there is a mention of this issue, it's brief, tends to be, and not really getting to the key points and significance, I'm afraid, And I'll give you an example. Do you remember the how uptight the freedom movement got? It sort of allowed itself to get it whipped up into an absolute frenzy about a school that they wrongly claimed, by the way, was cancelling Easter. Do you remember that? Back in April or whenever it was. Yeah, and in fact, it turned out not to be true, actually. It was just a change of procedure and policy. Yeah, but this was the kind of thing that instead of this, which is a causal issue, trial by jury, that affects your constitutional governing framework, when you could actually make much more significant, foundational, grounded and profound arguments affecting liberty and freedoms, we get absolutely nothing. Yeah. So even as another example, even the furore over the 2 lines in the sentencing guidelines. Yeah, it's outrageous. 2-tier justice. Remember all that? But over this, where your trial by jury is being threatened, relative silence. Yeah, over an issue where you'll get much greater, more radical destruction of your justice. Yeah, over this issue, right? Come on, this is not impressive, right? Now, in mainstream circles, the political class and the legal profession, the issue is that although they do seem to care very much, there is a sort of a missing piece, if you like, in the way that they're expressing it. So what is that? Because actually, whilst many are sort of saying really good things, jury trial is a fundamental, it's part of our constitution. What else are they saying? It's a right, it's a bedrock, it's a cornerstone, it's a bulwark, right? All of these things have come out in many of their tweets. Brilliant, yeah? But that doesn't translate into the fact that therefore, if anyone is making these proposals, they would be illegitimate. Yeah, in other words, they misunderstand, I think, the fact that if it's a constitutional principle, trial by jury, as you are rightly claiming, then attempting to remove it would be criminal. Yeah, that would be government stepping outside lawful behavior. Yeah, there seems to be a lack of clarity on that. Yeah, the Constitution binds government, the whole of government, not just the executive or the current government. Yeah, it's the whole machinery of government. Yeah, so am I surprised at this? No, of course not. Because we know that, the mainstream world and to some extent in the freedom movement as well, does not understand how the Constitution is supposed to function. They broadly think that the law is whatever government tells them that it is. That's the problem, right? So even though many of the arguments are astute, accurate, passionate, what they lack is the foundation of understanding that the government has no business to be proposing this in the first place. That's the issue, yeah? So in other words, it's affecting the language. It's weaker than it should be. Now, let's look at that a little bit more deeply. So what have we noticed? If you've been following this, you'll have noticed that this is being expressed in the following ways, right? Changes to trial by jury was not in Labour's manifesto, so they shouldn't be doing this, right? It's nothing to do with that. It's not a political opinion. Just because it didn't appear in their manifesto, it's got nothing to do with that. This is a constitutional issue, right? It sits above that. Yeah. Here's another one. We must vote them out at the next election. No, it's nothing to do with that. You're making it political opinion. You're bringing it down from up there to down here. That's not the issue, right? They must put it to a referendum, right? Again, it's nothing to do with that, because what if in a referendum people actually did vote out trial by jury because they were kind of kidded into thinking that that actually this is the only solution to the problem that we've got. No, that would still be unlawful. You can't do that constitutionally. Yeah, we must petition. Yeah, there's another one, right? So it's all sort of like you're asking for permission or pleading. Yeah, it's a deep-rooted problem in the psyche, right? It reveals a fundamental compliance with what they see as authority. Yeah, that's the issue. And it's not accurate. Yeah, when government steps outside constitutional principles, they are to be reined in by all of us, including lawyers. So people are struggling to think outside the box of politics or political opinion. Yeah, the only way to fix this problem is to get a kind of majority opinion together. That's the way that the thinking is going. So before we get into the proper arguments and maybe demonstrate how we're sort of helping to remind them, let's have a look at some examples and what they have been saying, what is being said, because it's good, right? So here's an example of, so this is Robert Courts, who was the Solicitor General. Okay, this is good. This is really good, right? Listen to this. Lammy's framing is the tell. Calling jury trial a tradition is a way of avoiding the issue. This is a fundamental point about liberty. If that is now dismissed as nostalgia, then the country really is in a bad place. Juries aren't some heritage item or page in an old textbook. They are the citizens' protection against the state. They remain the only mechanism that can acquit when the state overreaches. That's what Magna Carta is really about. I haven't finished yet. This is me just jumping in with a bit of commentary. I mean, this is brilliant. This sounds like something that comes out of commonlawconstitution.org. And yet here we are, a lawyer speaking truth here. It's brilliant. I'm going to carry on. There is a backlog, and it's certainly true that it cannot continue. Yes, that is of itself a threat to justice. But scrapping juries won't clear the backlog. The major limiting factors aren't jury speed, but prosecuting agency capacity and the collapse in the number of criminal barristers willing and able to take cases at all. Without lawyers, trials don't happen, judge only or otherwise. To govern is to choose, and this government has just gone on a massive tax and borrow spending spree on benefits. That was a political choice, one to appease their backbenchers rather than to prioritise justice, which alongside defence is one of the few things that only the state can do. And to an extent the plan works, it will be because magistrates convict more readily. That should alarm anyone who cares about liberty, not reassure them. Lammy doesn't confront these realities. He recasts a constitutional safeguard as a museum piece, while presenting what is a political decision to perpetuate a structural failure as an excuse for the state to expand its own power. A system with an 800-year safeguard should not abandon it for managerial reasons. A government calling itself progressive should not treat liberty as an optional extra. Right? It's fantastic. I don't know who tweeted this one, but this is just a short one. Very good. Trial by jury goes back to the reign of Henry II. It has survived not only the Stuarts, but also the Wars of the Roses, the Reformation, the Industrial Revolution, the Napoleonic Wars, 2 World Wars, and the Cold War. But it can't survive Keir Starmer and David Lammy. That's very good. Right? The Secret Barrister tweeted this. As set out in this thread, the causes of the court backlog are chronic lack of funding and absurd inefficiency. The government has made no proposals to address either. Their answer is to remove juries. Rather than fix the leaking roof, their solution is to burn the house down. Brilliant. Yeah, we had Philip Murray starting a thread on Twitter, which was very interesting, putting in some historical quotations, making reference to trial by jury, and that was great, by the way. He said, here's what some important historical figures said about trial by jury. And the first one he listed was the anchor quote from Thomas Jefferson. I consider trial by jury as the only anchor ever yet imagined by man, etc., etc. Brilliant quote, that one. He quoted John Adams. He quoted William Blackstone, which was that famous one, the trial by jury ever has been and I trust ever will be looked upon as the glory of the English law, etc., etc. Really good quote. He quoted Lord Devlin. Trial by jury is more than an instrument of justice and more than one wheel of the Constitution. It is the lamp that shows that freedom lives. That's a really good quote, that one. He quoted Chief Justice William Rehnquist. That's an American judge, I think. And Sir William Holdsworth. And many others. And others pitched in. There were some really good ones in there. And I joined in as well. So really good. Chris Dorr, who's a lawyer, has been doing some fantastic stuff. And I think he's been interviewed on Talk Radio, maybe GB News as well. I'm not sure. But anyway, he's been doing some really good stuff. He wrote this. Have a listen to this one. Time for action and unity. I have received countless messages from fellow criminal barristers today after speaking about jury abolition on 5 Live this morning. Every single one said the same thing. When are we going to make it clear that no criminal barrister with a conscience would agree to conduct any trial which becomes judge only as a result of the changes announced today? That was Lammy's eventual announcement. Yeah. Continuing. I make my position crystal clear. I will not accept instructions to appear in any trial from which the right to jury has been removed by these unconstitutional proposals. I am prepared to stand on a picket line outside any court which looks to carry out these sham trials. Enough is enough. Leveson and Lammy should be ashamed to put their names and reputations and legacies to this perversion of everything we call criminal justice in this country. Wow. Now, this is rousing. It's really good to see. Yeah. Now, hopefully, it may not come to standing on a picket line, right? If we stand our ground now and call this out for what it really is, which is unconstitutional and criminal. That's the point that quite often is being missed, right? If you're saying that trial by jury is a principle, a constitutional principle and a fundamental, if you're saying that, which you're quite correct to say it, by the way, that means an attempt to remove it is not legitimate and potentially even criminal as well. It's unconstitutional. You know, misconduct in public office, maybe. So if government, I mean, this is an interesting one to think about, right? Because you could think of it like this, right? If government sort of proposed, you know, let's kill all the baby boys that are born at Christmas. This is quite seasonal, isn't it? You know, maybe we'll call it Herod's Law. Okay. You know, would Parliament sort of sit around discussing it? You know, should we do this in November? Should we put a limit on it? Or should we do it in December? Has it got to be done by Christmas? You know, we're going to have people inspected to make sure that they've killed their baby, you know, this sort of thing. Is this something we need to debate, right? You're not, you know, or would we recognize it for the crime that it actually is, right? That's the thing, isn't it? Yeah, getting rid of trial by jury is not obviously as heinous as that. Yeah, but it is in the same criminal category. Yeah, why? Because it's a fundamental that affects your principles of governance, not just for you, but for every generation potentially afterwards. Yeah, removing the people's mechanism of defense of future heinous legislation, like Herod's Law, that's the problem. If you remove the mechanism of defense for that kind of legislation, then that's why it's that serious, right? And by the way, before anybody suggests, you know, well, the ECHR is, you know, could protect us from this too. The answer is no, because they could remove that as well. It's a piece of man-made legislation, right? I discussed this, didn't I, at the end of my conversation with Claire Wills Harrison. Yeah, it's if you are going to argue that something like the ECHR needs to remain in place temporarily, what you absolutely must do at the same time, and I said this clearly, is that you've got to be talking about trial by jury every day. Because the one thing you don't rely upon is a piece of man-made legislation. Yeah, you've got to get this sorted. It's the trial by jury that you need to defend. Because that's the constitutional principle that protects you against bad legislation. Right? And otherwise you're removing equity from your system, from your governing system. And as I said, the very mechanism that allows the people themselves to say no to unlawful legislation. So I'm having a rant now. This is pretty key. Now, in answer to this is quite interesting. In answer to someone suggesting that trial by jury could just be for imprisonable offences, right? In other words, placing a condition on it, Peter Hitchens said this: a finding of guilt by a court, even if no prison follows, can devastate the life of the convicted person forever. This is the key bit. The idea that convictions which don't lead to prison should lack the safeguards of jury trial is a ridiculous misunderstanding of life and justice. Right, so he's absolutely clear there. He's saying that, yeah, he's got it. He's actually saying that you can't differentiate. Yeah, it doesn't matter whether they're going to be imprisonable offences or not. If you're going to go to prison on it, even if you're not, you still need trial by jury. Yeah, that's good. He's got that. This is the main piece, though, that's normally missing in the minds of many. You don't want a situation where the government decides the edges or boundaries of trial by jury. You can have it a little bit. You can have it this much, because we've decided you can have this much trial by jury, but not over here or here, right? It's either a principle or it isn't. Yeah, this is the piece that people don't get. The Constitution says that you don't and must never allow the government itself to define the limits of your individual rights and framework of governance. Yeah, because they'll ultimately have the power to remove it completely. It's a pretty basic logic that is being missed. Yeah, people are failing to understand that there are places that government must and cannot go when it's legislating. Otherwise, they will legislate away your constitutional protections. That's why I've always been saying, yeah, that the constitutional law cannot legitimately be written in the legislation, right? Legislation cannot contain constitutional law, yeah, because legislation can always be repealed or amended, right? Even if that's what they call constitutional statutes, which doesn't exist, by the way, it's made up by them. Because, you know, you can still remove that and amend it explicitly, you know, without, it's to do with implied repeal, which I'm not going to go into now. Right? You're breaching the common law when government attempts to legislate away pieces of your constitution. You're causing a breach of the king's oath to govern according to laws and customs. Yeah? But laws and customs in that context doesn't mean whatever parliament decides that it is or decides to legislate. If it did mean that, yeah, what would be the point of the promise? Yeah, if you can, you know, if you can govern according to laws and customs, but then you can change what the laws and customs are, it's just pointless. Yeah, people aren't getting this. So this is what somebody said back, interestingly, in a tweet, which is much more on our side of things. Exactly. The fact that 90% of criminal cases are dealt with in the magistrates' court is unlawful. You can't have a protective cornerstone of justice that the state can limit access to. Yeah, every time a new summary offence is created, we limit jury trial. Yeah, so that was good. Now, this is what one of our contributors, LW, put on Substack, and I made reference to it. And also, this was used in a reply and a response to the odd tweet of lawyers. Yeah, listen to this. This is key, right? So, the proposals get worse and worse. But in their atrocity, people must notice the problem with allowing the state to decide which trials will get a jury and which will not. Which offences will be sequestered away from the scrutiny by the people and which will not. And in that noticing, the people must begin to realise that this is what has been happening for a long, long time. That the slippery slope began a considerable time ago. And now we appear to be at the finale of that slippery slope. And when you realise this, you know that the solution is in reclamation and restoration of authentic trial by jury for all cases across the land. See, that's the point. Yeah, because you can't have trial by jury a little bit. As I said just now, it's either a principle or it isn't. Right, and all of these principles in our constitutional law are principles, right? You can't legislate them away. They're not for politics to touch. Now, I want to finish reading out a brilliant piece of writing by a guy on Twitter called S. Tominaga on X. Okay, go and have a look him up because and give him some support because he's writing brilliantly, and I want to read this out. Listen to this. What is being proposed is not a reform. It is a confession of contempt for the very people from whom the state claims its legitimacy. The jury is not a sentimental relic. It is the practical assertion that the citizen is sovereign in judgment, that the state must persuade the governed before it may punish them. Remove that, and you do not streamline justice. You sever the moral tendon that binds power to consent. For 8 centuries, the jury has been the visible line of demarcation between law and command. It is the one institution that tells authority, in plain and humiliating terms, that its conclusions are not self-authenticating. 12 ordinary minds, unbought and unappointed, are required to say, yes, this accusation has met the standard of proof. That is not romanticism. That is civilization's hard-earned distrust of concentrated power. The moment judgment becomes the private monopoly of professional tribunals, the citizen is no longer a participant in justice, but a subject of administration. The pretexts are always pathetic. Efficiency, cost, backlogs. These are the slogans of a managerial class that cannot imagine any value higher than its own convenience. Liberty is not a line item to be trimmed when spreadsheets groan. If a state cannot afford the safeguards that prevent tyranny, then it cannot afford to call itself legitimate. The cost of juries is the cost of freedom. The price of abolishing them is paid in fear, silence, and the quiet normalization of arbitrary rule. And notice the timing. We are told to accept this surrender just after a crackdown in which speech itself was treated as a prosecutable impurity, and people received grotesque sentences for words on a screen, while violent criminals walked out early under the same government's capacity regime. This is the logic of a state that has come to mistake dissent for danger and obedience for virtue. To place the whole weight of criminal judgment into the hands of a politicized bench after it has already shown how cheaply it values conscience is not merely reckless. It is the deliberate construction of a soft police order dressed in robes and euphemism. A compulsory digital ID system, hand in hand with the shrinkage of juries, completes the picture. Identification to watch you, tribunals to convict you, and a public square trained to keep quiet lest it be denounced as harmful. That is not a free society drifting by accident into error. That is a society being led, quite purposefully, into managed submission. If Scotland has any remaining instinct for self-respect, it should leave the Union rather than be dragged further into this antiseptic authoritarianism. A nation that values its own moral agency does not consent to be ruled by strangers who fear the verdict of ordinary citizens. Better an independent country with the courage to preserve trial by peers than a subordinate province in a kingdom that barters ancient liberties for bureaucratic tidiness. Juries are critical because they embody the only political principle worth defending, that the individual is not livestock in the state's corral. They are the institutional reminder that justice is not what officials declare, but what free men and women hearing evidence under law are willing to affirm. Take that away, and you have not improved the law. You have replaced it with authority's monologue, and a monologue is always the language of tyrants, whether they whisper it in velvet tones or shout it through sirens. Thank you for watching.